हेलो गाइस, वेलकम बैक टू लॉस्टॉर्मिंग प्लेटफॉर्म। मैं हूँ शालिनी और आज के इस वीडियो में हम डील करेंगे फ्री कंसेंट से। अगर आपने इसके पहले की वीडियो नहीं देखी है देन प्लीज़ वॉच इट। उसका लिंक नीचे डिस्क्रिप्शन बॉक्स में और ऊपर कार्ड में मेंशन्ड है। और अगर अभी तक आपने चैनल को सब्सक्राइब नहीं किया देन प्लीज़ सब्सक्राइब टू लॉस्टॉर्मिंग। लेट्स स्टार्ट विद द वीडियो। नाउ फ्री कंसेंट को समझने से पहले लेट्स अंडरस्टैंड व्हाट द टर्म कंसेंट मीन्स। So the maximum consensus at EDM says that two or more persons are said to consent when they agree upon the same thing in the same sense. Let's take an illustration. A agrees to sell his house to B. A owns 3 houses and wants to sell his house in Haridwar. B thinks he is buying the house in Delhi. Now here A and B have not agreed upon the same thing in the same sense. अगर A को हरिद्वार वाला घर बेचना था और B was thinking कि हाँ वो he is buying हरिद्वार वाला ही घर, then it would have been a valid consent. But यहाँ पे both of them are thinking different things and therefore there is no consent and no contract is concluded in this case. So valid consent के लिए ये important है कि जो पार्टी offer कर रही है and जो पार्टी accept कर रही है they have the same thing in their mind. After this, let's understand free consent. So, Section 14 of the Indian Contract Act defines free consent. Now, Section 14 says consent is said to be free when it is not caused by, firstly, coercion, which is defined under Section 15, undue influence, as defined in Section 16, fraud, as defined in 17, misrepresentation, as defined in Section 18, or mistake subject to the provision of section 20, 21 and 22. So section 14 define करता है free consent and section 15 to 22 lays down the scenarios जिन cases में consent is not free. Now let's understand each of these terms separately. First of all, coercion. So coercion is defined under section 15 of the Indian Contract Act. It says coercion is committing or threatening to commit any act forbidden by Indian Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person with the intention of causing any person to enter into an agreement. The explanation says that it is immaterial that Indian Penal Code is in force or not in force in the place where the coercion is employed. So if we look at the element of coercion, coercion क्या होता है? या तो commit करना या threaten करना to commit any act जो कि prohibited है Indian Penal Code में, या फिर अनलॉफुली डिटेन करना किसी प्रॉपर्टी को या फिर थ्रेटन करना टू डिटेन एनी प्रॉपर्टी विद द इंटेंशन ऑफ कंपेलिंग अ पर्सन टू एंटर इनटू अ कॉन्ट्रैक्ट. सो कोई भी अगर किसी को थ्रेटन करके या उसकी प्रॉपर्टी को डिटेन करके या थ्रेटन करके टू डिटेन हिज प्रॉपर्टी किसी का कंसेंट लेता है देन दैट कंसेंट इज विशिएटेड बाय कोर्जन. Let's take an example. A went out for a walk. B approaches A with a stranger, pulls out his gun and asks A to give all his possession. Now इस केस में the consent of A is obtained by coercion क्योंकि of course वो free consent नहीं है. And if the contract is vitiated by coercion, उस केस में वो contract voidable होगा. Now what does this mean? It implies कि contract can be avoided at the discretion of the party whose consent was not free. Which means कि जो aggravated party है that person can determine whether he will enforce the contract or he will cancel the contract. उसके पास ये option है. So the aggravated party can either enforce the contract or he can cancel the contract. Now let's understand undue influence. So undue influence is defined under section 16 of Indian Contract Act. It says a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other, firstly, and secondly, that party uses that position to obtain an unfair advantage over the other. So हम कब कहते हैं कि कोई पार्टी किसी को इन्फ्लुएंस कर सकती है? When that person can exercise some authority over the other, right? So जहाँ पे एक पार्टी ऐसे पोजिशन में है कि वो दूसरे के डिसीजन को इन्फ्लुएंस कर सकती है एंड वो पार्टी अपने उस पोजीशन का एडवांटेज उठा के अनफेयर एडवांटेज उठा के दूसरे के डिसीजन को अगर इन्फ्लुएंस करती है then this is called undue influence. So when can we say a person is in a position to influence or dominate the will of other? Firstly, where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other, or secondly, where he makes a contract with a person whose mental capacity is temporarily or permanently affected by either age, illness, or mental or bodily distress. Now, what does the term fiduciary relation means? It means a relationship of trust and confidence. So some of the examples of fiduciary relationship include solicitor and client, spiritual advisor and devotee, parent-child, master and servant, guardian and ward, etc. So if we take an example, a man enfeebled by disease or age is induced by B's influence over him as his medical attendant. So here A, who's a ill person, is induced by his medical attendant to agree to pay B an unreasonable sum for his professional service. So B over here employs undue influence, and therefore A's consent here is not free but vitiated by undue influence. Alright? Now, section 16, subsection 3 says where a person who is in a position to dominate the will of the other enters into a contract with him and the transaction appears on the face of it or on the evidence adduced to be unconscionable, then in that case, the burden of proving that such contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Let's take an example. A, being in debt to B, the money lender of his village, contracts a fresh loan on terms which appear to be unconscionable. Now, unconscionable means unjust or not reasonable. So, in this case, it will lie upon B to prove that the contract was not induced by undue influence. Okay? So, if the contract appears unconscionable and दो पार्टी के बीच में ऐसा relation है, fiduciary relation है, then the court will presume कि undue influence exercise हुआ था. अब उस पार्टी को प्रूव करना होगा जो डोमिनेटिंग पोजीशन में है कि उसने कोई undue influence exercise नहीं किया है. ठीक है? Now let's understand fraud, which is defined under section 17 of Indian Contract Act. Section 17 says a fraud means and includes any of the following act committed by a party to a contract or with his connivance or by his agent with the intent to deceive another party thereto or his agent or to induce him to enter into the contract. First, suggestion as a fact of that which is not true by one who does not believe it to be true. So if someone is suggesting something as a fact, knowing it is not true, then that is fraud. Secondly, the active concealment of a fact by one having knowledge or belief of the fact. Third, a promise made without any intention of performing it. Fourth, any other act fitted to deceive. And fifth, any such act or omission as the law specially declares to be fraudulent. So अगर कोई भी इन पांचों में से कोई भी एक्ट करता है with the intent to deceive, then that person is said to commit fraud. After this, the section says कि mere silence as to fact likely to affect a person's willingness to enter into a contract is not fraud. ठीक है, तो silence as per this section is not fraud, but इसमें भी exception है. Silence will be treated as fraud if the person who is silent had the obligation to speak or unless his or her silence is in itself equivalent to speech. Now let's understand this with an example. A sells his horse to B by auction, which A knows to be unsound. A tells B nothing about the unsoundness of the horse. This is fraud on part of A because उसकी duty थी यहाँ पे, he was obligated to speak and he didn't, so he has committed fraud. After this, let's understand misrepresentation. So misrepresentation section 18 में defined है and it says that misrepresentation means and include firstly positive assertion in a manner not warranted by the information of the person making it of that which is not true though he believes it to be true. ठीक है, तो यहाँ पे the person who is asserting उसे खुद ही नहीं पता है कि जो वो बोल रहा है वो गलत है. He under honest belief that what he is speaking is true makes an assertion, but वो fact actually गलत है. ठीक है. Secondly, any breach of duty which without an intent to deceive gains an advantage to the person committing it. And thirdly, causing innocently a party to an agreement to make a mistake as to the substance of the thing, which is the subject of the agreement. Now, misrepresentation is different from fraud क्योंकि यहाँ पे जो party assertion दे रहा है, firstly, he is under an honest belief that what he is saying is true. Secondly, जो word important है second में is that he is making an assertion without an intent to deceive. The breach of duty is caused without an intent to deceive. And thirdly, he is causing the other party to make a mistake as to substance of the subject of the agreement, but that mistake is caused innocently. So misrepresentation के केस में defraud करने का या फिर deceive करने का कोई intention नहीं होता है. All right? After this, let's understand the effect of vitiated agreement. So section 19 talks about voidability of agreements without free consent. So जहाँ पे consent is caused either by coercion या फिर fraud या misrepresentation. तीन scenarios में coercion, fraud or misrepresentation. Then in that case, the agreement is a contract voidable at the option of the party whose consent was so caused. ठीक है? तो अगर कंसेंट इज कॉज्ड बाय कोर्जन फ्रॉड या मिसरिप्रेजेंटेशन देन द पार्टी जो अग्रीव्ड पार्टी है वो अवॉइड कर सकता है कॉन्ट्रैक्ट को बिकॉज द कॉन्ट्रैक्ट इज वॉइडेबल. However, there's an exception to this. It says if such consent was caused by misrepresentation या फिर by silence which is fraudulent within the meaning of section 17 and जो पार्टी कॉन्ट्रैक्ट कर रहा है उसके पास ऑप्शन था to discover the truth with ordinary diligence and he did not do that, then in that case the contract is not voidable. ठीक है? तो अगर कोई ordinary due diligence से truth को discover कर सकता है और अगर उसने नहीं किया in case of misrepresentation and silence fraudulent within the meaning of section 17, then the party is not in the position to avoid the contract. ठीक है? After this, let's understand effect of contract which is induced by undue influence. So section 19 deal करता है coercion, misrepresentation and fraud से and section 19A talks about undue influence. So 19A says power to set aside contract induced by undue influence. When consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of party whose consent was so caused. And any such contract may be set aside either absolutely or if the party who is entitled to avoid it has received any benefit thereunder, then upon such term and condition as the court may seem just. So 19A के under the aggrieved party can avoid a contract which is vitiated by undue influence और अगर उसने कोई benefit ली है under the contract, then in that case the contract will be avoided as per the terms and condition which is imposed by the court. The illustration says A's son has forged B's name to a promissory note. Now B, under the threat of prosecuting A's sons, obtain a bond from A for the amount of forged note. In this case, if B sues on his bond, the court may set the bond aside because it is obtained by exercising undue influence on B. Now after this, let's understand mistake. So there are two forms of mistake under the Indian contract law. First is mistake of fact and second mistake of law. Now mistake of fact arises when one or both of the contracting parties have misunderstood the term that is essential to the meaning of the contract. Now mistake can be of bilateral nature or unilateral nature. Mistake is bilateral when both the parties to contract are under mistake of fact which is essential to the agreement. Then it is bilateral mistake and bilateral mistake is also referred to as mutual or common mistake. Unilateral mistake कब अगर होता है when only one party to the contract makes a mistake. Now section 20 to 22 deals with mistake. Section 20 and 22 talks about mistake of fact and section 21 talks about mistake of law. Section 20 says that agreement is void where both parties are under mistake as to matter of fact. So जहाँ पे bilateral mistake है and दोनों parties are under mistake as to matter of fact, then उस case में agreement is void. Section 22 says contract caused by mistake of one party as to matter of fact is not voidable, which means अगर सिर्फ एक party को mistake है, unilateral mistake है with respect to matter of fact, then उस case में the contract is not voidable, which means the contract is valid. Alright? After this, section 21 talks about mistake of law and what is the effect of mistake as to law. So a contract is not voidable because it was caused by mistake as to any law in force in India. So अगर mistake is caused with respect to law which is enforced in India, then the contract is not voidable. मतलब contract valid है. But अगर mistake is caused with respect to any law not in force in India, which means अगर mistake is caused with respect to any foreign law, then it will have the same effect as a mistake of fact. Now, same effect as mistake of fact का मतलब क्या हुआ? Again, foreign law के respect में अगर both the parties are mistaken, then the contract will be void. Only one party is mistaken with respect to foreign law, then in that case the contract will not be voidable, which means it will be valid. ठीक है? तो mistake of foreign law के case में the effect will be same as that of mistake of fact. Let's take an illustration. A and B makes a contract grounded on the erroneous belief that a particular debt is barred by Indian law of limitation. Now, इस केस में the contract is not voidable because mistake as to Indian law does not make a contract voidable. वो contract valid होगा. ठीक है? Alright, with this we have come to an end of the video. Thank you guys. If you like the content, then please like, share, comment your suggestions in the comment box below, and please subscribe to Lawstorming channel.